Children in contact with the law. Under the Child Rights Law of Lagos State 2015 as amended, this can be summarily referred to as the procedures which safeguarding and child protections officer take, such as police officers, social workers who work with children, vis-a-vis the provisions of the law to safeguard children who are victims and witnesses of violence. Simply put, this refers to children who have been or likely to be abused in any form and how to protect them. Basically speaking, it just makes provision for how and what to do, how to go about it. Children in need of care. This speaks to cases where children have been identified beyond reasonable suspicion to be in need of care. With a care order from the family court, such a child will be placed in a temporary shelter. For example, a child who has experienced severe physical abuse by a parent or both, a child who has been sexually abused and the family members are involved in the perpetration of such an abuse, a child who has experienced trauma, some form of trauma where the family member are culpable, a child who, for instance, has been neglected by a family member or both parents and has been exposed to different forms of harm. In such a situation, the child can be removed from the family environment and placed in a protective custody, pending the determination of their case. Children taken into police protection in cases of emergency. Sections 36 to 39 of the CRL 2015 address emergencies such as the child who was abused sexually by one or both parents or as a result of the negligence of the primary caregiver. Such children will be taken to the Police Juvenile Welfare Center, JWC, as earlier mentioned, temporarily, while awaiting a care order for placement to a temporary shelter, such as a transit home or a children's center. So, for example, a child who was removed as a matter of urgency from an environment and a care order has not been issued by the court, the child can be taken to a juvenile welfare center, which has the power to hold the child for a maximum of 72 hours, pending when a care order will be granted by the court for the child to be placed in an appropriate accommodation or facility. Prohibition of exploitative labor. Abuse of children, such as bullying, selling, or hiring of children, etc., provided for in sections 23, 25, and 26, address child labor and children who experience bullying by peers or students in school or within their community. The case of bullying in schools, for example, has become so rampant now. And in our society, especially in Lagos, we have different cases of children who have been brought from rural areas to urban centers to be used as house helps, sales girls, and so on and so forth. And oftentimes, they are deprived of different forms of rights, such as right to education, right to family life, and so on and so forth. And those children become vulnerable because they are no longer with their family members who can protect them and provide adequate care for them. They are given, activities or chores that are beyond their capacity to manage, and they are deprived from going to school at the right time. Sometimes they also face deprivation such as food, health care, good clothing, sleep, and so on and so forth. Other forms of sexual abuse and exploitation. Sections 27, 28, and 29 of the CRL 2015 address and prohibit any sexual activity with or against a child. Activities such as a show of pornography, videos, or images, sexual intercourse with a child, threat to life, etc. There are instances where children are used for pornography. There are instances where children are being groomed, particularly over the internet, without the knowledge of their parents. There are instances where children are involved or engaged in indecent conversations by an adult who sometimes might be a predator. And the only intention is to, cajole the child to such an extent that they then later prey on the child. All these instances are not acceptable based on the provisions of the CRL 2015. Prohibition of child marriage and betrothal. Sections 20 and 21 of the CRL 2015 prohibits children from being married until the age of 18. That is the age where it is assumed they have reached a majority and they can make a decision concerning what is best for them regarding marriage or betrothal. Marriage should be a mutual consent or agreement between two well-informed adults. This section also sanctions betrothal and child marriage. In addition, there are other categories of children who come in contact with the law. For instance, children who are involved in matters relating to custody, access, maintenance, and domestic violence also come in contact with the law during the course of, hearing the matter in the court, and they are also exposed to the justice administration system.